Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yes.
May it please, my lord.
You are the appellant before the. You are the appellant before the.
Lower appellate court, your lordship.
Before the district council court.
Yes, your lordship.
And you are the bank.
Yes, your lordship.
Are you a scheduled bank?
Yes, your lordship. We are a scheduled bank.
So you are covered by the Securitization Act.
Yes, your lordship.
Very good. What is the reference?
Your lordship, actually what had happened was that, your lordship, the one lady, Hamsarang Longwar, your lordship, who was the respondent number 2 in the lower appellate court, your lordship, had taken a loan from the Meghalaya Rural Bank. And when the money had, she had failed to pay the loan, we invoked the Surfacy Act, your lordship, and issued notice under section 13.2 and section 13.4 of the Surfacy Act, your lordship. Then after that also, when there was no response from them, we have taken the assistance of the Deputy District Magistrate, and in the presence of the Executive Magistrate and the police officials, we have taken physical possession of the property that was mortgaged with the bank, secured asset of the bank, your lordship. Now, after we had, that was done on 3rd of February 2022, your lordship. Now, after we had taken physical possession of the property, your lordship, the appellant before the lower appellate court, your lordship, who claims to have purchased the property which was mortgaged at the bank in the year 2012 from the borrower.
When does he claim to have purchased the property?
That was much after 2012.
No, much after 2012.
2012, your lordship. And then.
When did he file the suit?
He filed an eviction suit against the borrower because the borrower was still in possession of the property. In 2000, when was this filed? In 2000, because we were not made a party in the eviction suit, your lordship.
When did he file the suit?
I think they filed the suit in the year.
Yes, tell us.
When 2018, my lord.
2018.
2018, my lord.
2018.
18.
And when did you get the decree?
The decree, my lord,
2021, Your
2 of
Lordship.
2021, my lord. 2021.
2021. By then you were already in possession.
We had already issued notice under surface 13.2 and 13.4 by then, Your
When did you
Lordship.
issue 13.2?
13.2 was issued, Your Lordship, in 11/12/2017.
Did they respond? Did she respond?
No, she did not
When was
respond.
your 13.4?
13.4 was on 8 March 2018, Your
And
Lordship.
what measures did you take?
Then, Your Lordship, after there was no
When did
response,
you file your section 14?
Section 14, Your Lordship, we have filed in the year 2022, 28/1/2022.
28/1/2022. Very good. The reference finish it, brother. Give us an act. The reference here has been made by the additional judge of the Additional District Council Court, Khasi Hills, Shillong. Full stop. Some basic facts need to be noticed before the questions raised by way of this reference are taken up for consideration. Paragraph. According to the respondent bank, which claims to be a scheduled bank and to which the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 applies, granted a loan to the second respondent. Where is the cause title? Give us the cause title in the lower court.
My lord, respondent.
Second respondent.
Yes, my lord.
In the appeal, she's not been made a party.
In the appeal, she is not a party.
The bank is a party, Your Lordship.
2-1. What was her name?
Hamsarang Langwar,
In the year 2012.
2012, Your Lordship.
Such in the 2012, the loan.
The loan was given on the year 2012.
According to the respondent bank, the loan was covered by the mortgage of an immovable property where?
In Maulai Yoring Hep.
In Maulai Yoring.
Yoring Hep.
Full stop. Paragraph. It appears that the mortgagor subsequently purported to sell the property to the appellant herein and, in or about 2018, the appellant filed a civil suit before the relevant district council court for eviction of the mortgagor and possession of the property. Full stop. A decree followed and eviction proceedings were levied. Full stop. Paragraph. In the meantime, according to the respondent bank, upon the mortgagor failing to repay the loan, a notice under section 13(2) of the said act was issued, to which the debtor did not respond. Full stop. The bank claims that a further notice under section 13(4) of the act was issued and the bank took measures thereunder for realization of its secured interest. Full stop. Indeed, the bank also approached the appropriate authority under section 14 of the act and, pursuant to administrative directions issued thereupon, claims to have taken possession of the property in question. Paragraph. There is no dispute that the property which was sold by the mortgagor to the appellant was the same property that was mortgaged by the debtor to the bank herein. Paragraph. Upon the in the appeal before the District Council Court, comma, upon the issue arising as to the rights of the purchaser, comma, namely the appellant in that court, vis-a-vis the bank, comma, namely the respondent in that court, comma, the District Council Court thought it expedient to frame the following legal questions for reference to this court set out, A, B, C, D, from page 7 of the order. I'll give it to you. Where the execution warrant stroke order of court should bend down before notice pasted by the respondent bank. B, whether the judgment and decree passed by a lower court or the notice issued by the bank under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act has supersession power over the other. C, whether it is the appellant decree holder or the respondent bank should approach the court of competent jurisdiction to adjudicate the matter. Question mark, if so, comma, which court has jurisdiction to adjudicate the same? Question mark. D, in the event no further adjudication is required any longer, comma, in such a circumstance and in regard to the question of redemption stroke preemption, comma, whether it is the appellant stroke decree holder or the respondent bank has the right of redemption or preemption for recovery of the money to be realized from the properties of the judgment debtor? Question mark. Paragraph. The said Act of 2002 is somewhat unusual and goes against the grain of the fundamental principles of law theretofore established in this country. Full stop. Under the jurisprudence that was in place, comma, a claimant had to approach a court of law to establish the claim before the claimant could pursue any property over which the claimant asserted rights. Full stop. Paragraph. However, comma, since claims by banks, comma, both in respect of money due and properties mortgaged to banks, comma, remained embroiled in courts for years and the money was lost to the system or remained blocked, comma, there was first a Tiwari committee report followed by a Narasimhan committee report that resulted in an ordinance being brought in that later metamorphosed to the Recovery of Debts Due to Banks and Financial Institutions Act 1993. Full stop. However, comma, in less than a decade of such act coming into effect, comma, it was realized that the same process, comma, even though exported from the court to an exclusive tribunal by the name of Debt Recovery Tribunal, comma, continued, and the bank money blocked could not be unclogged. Full stop. Paragraph. In such circumstances, comma, there were further reports, comma, including a second report by the Narasimhan committee that resulted in, comma, in essence, comma, section 29 of the State Financial Corporations Act 1951 to be invoked for the purpose of a secured creditor having right to proceed against the security even before the claim of such secured creditor was adjudicated by any forum. Full stop. Paragraph. Indeed, comma, the complete answer to the issue has to be found in section 34 of the said Act of 2002, colon, set out section 34, paragraph. Section 30, the above provision has two limbs, colon. The first limb is that no court shall entertain any matter which the debt recovery tribunal or the appellate tribunal is empowered to adjudicate, semicolon. The second limb is that no civil court or other authority shall issue any injunction in respect of, well, just check the act, in respect of any injunction, will issue any injunction in respect of any such matter which is capable of adjudication by a debt recovery tribunal or appellate tribunal. Full stop. The provision, aforesaid provision, has passed muster, and a challenge to the vires thereof was repelled in the Supreme Court judgment of Mardia Chemicals, reported at, I'll give you the reference, full stop, paragraph, thus, a debt recovery tribunal or an appellate tribunal, as the case may be, has primacy in a matter when there is a claim by a scheduled bank against a debtor or a secured or a secured interest or mortgage property. Full stop. Paragraph. In any event, even without the said act being in place, on the basis of the facts in the present case, the answer is simple. Full stop. Once a mortgagor had mortgaged a property in favor of a mortgagee, the mortgagor has a limited right of redemption. Full stop. Thus, any sale subsequent to a mortgage being created is subject to the rights of the mortgagee, and the subsequent purchaser cannot claim any rights in excess of the mortgagee. Full stop. Indeed, the only right the subsequent purchaser can claim is to exercise the right of redemption in place and stead of the original mortgagor. Full stop. Paragraph. Accordingly, the reference is answered by observing that in view of section 34 of the said act of 2002 and the very scheme of such enactment, no civil court or other authority will have a right to adjudicate on the claim of any person in respect of a secured interest against which a bank covered by the said act of 2002 has proceeded by taking a measure under section 13(4) of such act. Full stop. Paragraph. CREF number 1 of 2023 is disposed of. There will, however, be no orders to pass. Yes.
From the main list, item number 1.
May it please Your Lordship, this is the matter for illegal coal, my lord.
Yes.
As per Lordship's order of 2nd of May, my lord, certain directions were given to the private respondent as well as to the customs authorities as well as to the government of Assam, my lord.
Yes.
So,
yes, Dr. Modika.
my lord.
May I please, Your Lordship?
Yes.
So for the state of Assam, I have I got a report from the SP of BIO.
Yes.
And that report, we have served the copy to the petitioner and to the counsel for the other side. And for the court also, it is placed. Kindly have a look.
Yes, where is that copy?
The second, they want to say that this huge quantity of coal is not available readily in the market.
Pursuant to the previous order, we'll give them a chance. Pursuant to the previous order, the state of Assam has filed a letter dated May 16, 2023,
19. As per to the 19, last line.
Under cover whereof, the Superintendent of Police has forwarded a report pertaining to the possibility and feasibility of the respondent number 14 having lifted huge quantities of coal during 2021 and thereabouts from the open market in Beltola or its surrounding areas. Full stop. Paragraph. The relevant report, which is by way of a letter issued by the Inspector of Police, Bureau of Investigation (EO) close, Assam, to the Superintendent of Police of the same Bureau of Investigation, observes as follows. Observes, inter alia, as follows. Colon, open paragraph. During field verification, several coal depot / dealer have been visited. And on being inquired about possibility / feasibility of dealing of huge quantity of coal covering the period from 2021, it has been revealed ... that since 2014, the business of coal has drastically come down, and after strict guidelines issued by the NGT in respect of mining / extraction of coal from Meghalaya, full stop. Hence, possibility of dealing of huge quantity of coal was not feasible on the part of any of the coal trader located in Beltola area, full stop. In case of demand of large quantity of coal by any customer, which happens in very rare occasions, the coal dealer have to procure it from Nagaland, full stop. The close quote. The conclusion in the report is that it is unlikely that the respondent number 14 would have obtained the huge quantity of coal that it sought to export from the open market in or around Beltola. Full stop. Copies of such field report and letter have been circulated both to the state of Meghalaya and to the 14th respondent along with the petitioner. Full stop. Paragraph. In the light of such field report and conclusion, both the state and the 14th respondent will respond thereto when the matter appears next, a fortnight hence. Full stop. Yes, Dr. Mudikar, do you have the papers?
My lord.
What papers do you have?
My lord, I have the papers of e-way bill, my lord, which have normally what happens, my lord, when a truck comes to land customs station, may I just hand over the copies, my lord? The original copies here, my lord.
Yes.
So, Lordship will see this is the e-way bill of Jaima Coal Private Limited.
Of?
Just below the line, my lord, the first line, Jaima Coal Private Limited, who is the 14th respondent, my lord.
Just below the first line? Yes.
First below the
yes.
line, line, my lord.
Yes, so e-way bill, yes.
Then, my lord, it is checked that Dinah Dubey, the seal and signature is there by the sealed and checked Dinah Dubey, my lord.
Sealed and checked. Where do you find that?
Below, my lord.
On the first page?
On the first page, my lord.
E-way bill number, e-way generated, valid from?
Well, below the signature and rubber stamp is there, my lord.
Yes, signature, rubber stamp, sealed and checked.
Dinah Dubey,
what is that?
This is to indicate, my lord, the truck has entered Meghalaya from Assam, my lord, to
Yes.
the Dynadubi check gate. And there it has been signed by one DMR official, my lord. And then again seal OK at Gasuapada, my lord. And this is again directed to Mineral Resources, my lord.
Yes.
So, my lord, we rely on the certification by the Directorate of Mineral Resources, Government of Meghalaya, my lord.
There is also a letter to the Chief Secretary by.
My lord, we have been flagging this issue, my lord, with the state government for several occasions, my lord.
Very well. We'll give both of them call for a response. We can't simply. Several papers have been brought on behalf of the customs authorities pursuant to the previous direction. Full stop. Such papers include a specimen e-way bill. Full stop. The sample bill is dated December 16, 2021 and was produced by Jayama Coal Private Limited at the Kasuapara Land Custom Station for the purpose of exporting. What is the quantum?
Next page will indicate, my lord, 12 MT, 12 metric tons.
For the purpose of exporting 12 metric ton of washed blend coal. Full stop. The customs authorities point out that as far as they are concerned, they are required only to check the e-way bill, and the original e-way bill indicated above bears the signature and rubber stamp of the Government of Meghalaya and its Directorate of Mineral Resources at two places, one at Dynadubi, when the relevant truck may have entered the state, and the other at Gasopara as it crossed just before it reached the Gasopara LCS. Full stop. Paragraph. The customs authorities have also produced a copy of a letter dated March 9, 2022, issued by the issued by the Commissioner of Customs Preventive, Northeast Region to the Chief Secretary of the state. At paragraph 3 of the letter, it is indicated that customs officers at land custom stations, through which coal is exported, are checking the relevant documents to ensure that illegally mined Meghalaya coal is not cleared for export. Full stop. It also refers to coal originating from outside the state of Meghalaya. In case of coal originating from outside the state of Meghalaya, the Mining and Geology Department of the Government of Meghalaya issues export permits or orders, and the period of validity of such permits or orders. Full stop. The letter refers to the provisions of the Mines and Minerals Development and Regulation Act 1957 and the rules framed thereunder, and the widespread reporting of illegal coal mining and illegal transportation of illegally mined coal in the state. Full stop. Paragraph. In short, comma, upon the LCS authorities receiving various complaints from various quarters, comma, they put the state of Meghalaya on notice that the state should ensure proper verification before permits or orders were issued for export of coal. Full stop. Paragraph. A further letter of May 4, 2022, issued by the Commissioner of Customs (Preventive) has also been brought. Full stop. There is a third letter seeking coordination between customs officials and state government, dated November 22, 2022. Full stop. In between, comma, not in between. A copy of a previous letter of November 11, 2019 has also been produced, where the Union Minister of Finance and Corporate Affairs had written to the Chief Minister of the state for mandatory checking of transport challan, since the customs authorities did not have the mandate to ascertain the origin of coal at the land customs stations. Full stop. Paragraph. Despite the present and several related matters in this court pertaining to illegal coal mining and pertaining to rampant illegal coal mining, despite orders of the National Green Tribunal and the Supreme Court in such regard from about 2014 or 2016, and despite several orders of this court requiring the illegal transportation of the illegally mined coal in the state being required to be checked and altogether stopped, comma, the state did not find it convenient to refer to any of the aforesaid letters, comma, particularly the letter issued by the Union Minister to the Chief Minister of the state. Full stop. Considering the discovery of rampant illegal coal mining, comma, the mushrooming of illegal coke plants without any permission or license, and the continuing transportation of coal across the length and breadth of the state, comma, including in trucks bearing no registration plates, comma, the role of the state government in utterly disobeying orders of the NGT and the Supreme Court, and in being complicit with the illegal mining mafia and the transport mafia, becomes rather obvious. Full stop. Paragraph. Since these documents have come to light just now, it is necessary to call upon both the state and the respondent number 14 to respond to the same. Full stop. Paragraph. Dr. Mozika is requested to forward copies of the aforesaid documents, including the e-way bill and the letters, under cover of a letter issued by his junior to advocate representing the state and advocate representing the respondent number 14. Full stop. This exercise should be completed in course of the day. Full stop. Paragraph. It will also be open to advocate for the petitioner to obtain the same set of copy documents from Dr. Mozika. Paragraph. It is expected that appropriate explanations in such regard and dealing with the observations pursuant to the field study conducted by the relevant police authorities in Assam and the documents relied upon by the customs authorities would be appropriately dealt with, particularly by the state of Meghalaya and the respondent number 14. Full stop. Copies of the relevant affidavits should be forwarded to both the customs authorities, the petitioner and the state of Assam at least one day before the matter appears next. Give it a date after 2 weeks.
But only one aspect, man.
Yes.
But in the
Yes, sir.
My lord,
Yes, sir.
so for the Assam government is concerned, my lord,
Yes.
we have not received the copy which the Assam government has.
Ask your junior over here to take it. You must be
Sure,
having
my
a
lord.
local junior over here. Ask your local junior to collect it.
my lord,
So for the state government is concerned, my lord.
in the letter of 4th May 2022, my lord.
Yes.
If lordships kindly peruse this,
4th May.
my lord.
Yes.
Para 2, my lord. In para 19.6.21 of the above mentioned order dated 22/7/2020 of the NGT, it was directed to establish integrated checkpost and tamper-proof weigh-in motion weigh bridge at each of the 7 LCSs in Meghalaya, and that these integrated checkposts should be jointly manned by the representatives of Mining and Geology Department, Forest and Environment Department of Government of Meghalaya, and representatives of the Customs and BSF. This office may please be informed whether the ICP and tamper-proof weigh bridge have been set up at the said 7 locations. My lord, it appears that these have not been set up, my lord.
Yes.
Lordship, I also had a prayer to file an affidavit because Lord,
Do it. Who is stopping you? You have not prohibited any affidavit being filed. Yes.
obliged.
What night?
Item number 2.
Lordship, in the last week, I've got some personal difficulties in the last week, Lordship, at least.
No, it'll appear after 2 weeks. We don't care. This matter we really
I'm obliged.
Item number 2.
Wait, please, your lordships.
Yes.
My lord, these 2, 3, 4, 5, my lord, these are analogous income tax appeals, your lordship.
Who's on the other side?
He is appealing to PC, I think, Mr. Kyle.
I'm on PC.
Yes.
Yes, my lord. So these are analogous matter, my lord, income tax appeal arising from a common judgment. Now, my lord, the issue formulated substantial question of law, my lord, 2 substantial question of laws were formulated. Number 1, the tribal exempted from the tax under 1026, my lord, if they constitute a farm, my lord, are they still entitled for exemption? Number 2, your lordships, the ratio laid down in an earlier case by the Common High Court, my lord, that is Mahari and Sons, which say, my lord, it's not necessarily the individual tribal. Even if a group of tribal, my lord, conduct a business, still they are entitled for exemption. Now, my lord, other substantial question of this, whether this ratio laid down in Mahdi and Sons, my lord, should have been overruled or declared par imperium by the tribunal is correct. So these were two questions. So initially these matters were taken up by this bench, your lordship. In course of hearing, my lord, lordship had doubted the ratio laid down in Mahdi and Sons. And that's how the matter was referred to a full bench. But for some reason, my Lord Justice, thank you, he recused. Then the matter came back before this bench, your lordships. So on the last occasion, my Lord, the obvious reason, my Lord, for reference was this, that the settled position of law is this, that in case of exemption, my Lord, if there is any confusion, ambiguity, my Lord, it has to be done strictly, but in case of any ambiguity, your lordships, benefit will go to the revenue. This is the apparent reason why my Lord has referred that judgment, my Lord, for review before the full bench. Now, on the last occasion, my Lord, I had submitted, your lordships, that this is true, my Lord. The settled position of law is this, that in case of, my Lord, general exemption, my Lord, these are to be construed strictly. In case of ambiguity, will obviously go to the revenue. My Lord, that has been decided by a constitutional bench in 2018, I think, my Lord. We have referred to that judgment. But subsequently, my Lord, in 2021, my Lord, an issue came before the Supreme Court, my Lord, pertaining to, my Lord, exemption in the matter of, for a beneficial purpose. And there, my Lord, the earlier decision of the constitutional bench for general exemption was also referred to. Now, my Lord, in that decision, it has been held that general exemption and exemption for a beneficial purpose, they stand in two different footing, your lordships. And so far, the constitutional bench judgment of 2018, my Lord, that has not, my Lord, gone into the general exemption for beneficial purpose. That remained untouched, and ultimately the Honorable Supreme Court held, my Lord, so far as exemption for, my Lord, beneficial purpose is concerned, it has to be construed liberally, your lordship. Now, my Lord, after your lordship, we have placed those decisions before your lordship, but then lordship's tentative view, my Lord, was this. The so far 1026 is concerned, we are concerned with the, my Lord, identity of the exemptee, a member of the scheduled tribe, your lordships. And then again, my Lord, the purpose is something else, your lordship, and tribal itself is not the purpose. So that was the, my Lord, prima facie view of your lordships. But anyway, lordship was generous enough to give us some time, my Lord, to find out something more, if we can pursue your lordships. Now, my Lord, I'll try to, my Lord, pursue my lords. That,
yes, have you filed a compilation or anything? For the
no, Lordship, we file our affidavit, Lordship.
No, have you filed a compilation of judgments, not affidavit? Your affidavit is useless. It's a pure question of law. Affidavit is useless over here.
No, Lordship, we have not filed any compilation. Rather, my learned friend for appellant, he has filed two compilation, Lordship.
You don't want to contest it? If you don't want to contest it, why should we bother?
No, Lordship, we are contesting, Lordship.
If you are contesting, then we would want to know what law that you want to rely on. Because he has more or less finished his submission. We had given him an opportunity, he has more or less finished his submission. Now, if you don't want to rely on any law, then we'll conclude it and rule in his favor.
Lordship, I may be allowed 1 week's time to file compilation.
Because we've got to know what is we've got to see the judgments and then decipher from the judgments.
Lordship, allow me a week's time.
Have you found anything new in your favor?
Yes, my Lord. Yes, my Lord. I'll take. I don't know, your lordship. If he grants him time, it will come up again. And if your lordship permits me to make the submission, because one thing I have come across.
We want to finish it off right now, because right now meaning whenever you are ready, because it is one thing that you say that, where a benefit is given to somebody, as a beneficial legislation, then, is given to a member. So any dispute as to whether he will be a member or will be considered to be a member or not. Say for instance now, the district council is saying that if you take your father's surname, you will no longer be part of that. Now, in such a situation, when it is being interpreted whether 1026 benefit should be conferred to a person who has taken his father's surname or not, then we will construe in favor that if he had not taken the father's surname, he will be covered by this also. But you cannot say that read 1026, an exemption provision, in an expanded manner. It clearly says a member of the notified, whatever is scheduled. And if it says a member, then it indicates that member. It otherwise would have said an association of members or a conglomeration of members or a group of members, because your Income Tax Act makes a difference between associations, companies, partnership firms, individuals. Yes, there is some ambiguity between an HUF, but an HUF is a completely different matter. It does not involve us. And there are several provisions where you see that there is a distinction categorically made between an individual, meaning one person, and a group of individuals in the Income Tax Act itself. So once the Act is such that it does not treat a person with a number of similar persons, one person of a kind is not treated similarly as several persons of the same kind, then we cannot extend that. That is the primary reason. And those interpretations which are in the judgments, they have to be confined to the and last judgment was Justice Nariman's, I suppose, where he said that that Dilip Chandra case, where he said that Dilip Chandra case has to be confined to that. There's no beneficial and general exemption, those things. Those are sometimes used, but we have to see in what context. And the context over there, as far as we remember, was whether it extends to an educational institution or not, and whether a hostel being part of an educational institution or a nunnery being part of an educational institution was entitled to that or not. Now you got to see the larger picture. The larger picture is that all of those are units which make up an educational institution. You can't say that only the classroom is the educational institution, the toilet is not. The gymnasium is not the educational, but the practical, the laboratory is. You got to take the entire thing, and in that Kerala case, they had taken the entirety of, and said that this will be treated as educational institution. That is quite different from enlarging a member to a group of members. That is doing violence with the primary. So let him file his compilation. You also get to see that.
But so far this part is concerned, my lord, I don't know, my lord, when it comes up next, I need to take your lordship to the history of this exemption provision inserted into the Income Tax Act. Because this was originally not like this. This matter has travelled to the Supreme Court. Originally there was a rider, provided they are not government servant. That means tribals who were government servant, they were not eligible for exemption. That was challenged before the, my lord, Assam High Court then, in early 60s. Assam High Court struck out, my lord, that provision. Matter travelled to the Supreme Court. Now, my lord, this was placed before a constitutional bench. So, constitutional bench, my lord, while discussing whether the
arbitrary, completely arbitrary.
My lord,
there is no rational, distinction between government servants and non-government servants.
Exactly. And there, my lord, while my lord striking down, upholding the judgment of the Assam High Court, my lord, Supreme Court has answered, my lord, with reference to 1026. The exemption extends to whom? Is it to an individual? Supreme Court said no. It has given to a class. Because individual socio-economic status.
The Supreme Court couldn't have said that. The Supreme Court must have said it is given to members of a class. Members of a class. We are not disagreeing with that.
But anyway, your lordships, if, my lord, whenever it comes, I will try to convince your lordship on this point.
When will you be able to file the compilation?
Within 10 days.
Very well. Since the department seeks 10 days time to file its a compilation of the judgments that the department seeks to rely on, let the matter appear 3 weeks hence, full stop. Copy of the compilation should be filed in court along with a copy served on advocate for the appellants with fortnight from date.
My lord, with the permission of this court, my lord, I have prepared a short synopsis.
No, we don't want that.
Item number 6,